Are you ready to go?
Yes, sir. All set.
Good morning. The Judiciary Committee will come to order. Without objection, the chair is authorized to declare recesses of the committee at any time. We welcome everyone to this morning's oversight hearing entitled Access to Justice. Does DOJ's Office of Inspector General have access to information needed to conduct proper oversight? And I'll begin by recognizing myself for an opening statement. On August 5, 2014, 47 of 72 statutory U.S. Inspectors General signed a letter to Congress in protest of constraints that have recently been imposed on access to agency records, constraints that impeded efforts to perform oversight work in critical areas. The conduct of meaningful oversight by any Office of Inspector General depends on complete and timely access to all agency materials and data. As such, Section 6A1 of the Inspector General Act expressly provides for such access. Restricting or delaying an Inspector General's access to key materials, in turn, deprives Congress and the American people of timely information with which to evaluate an agency's performance. Limiting access, except in very narrow instances, is at odds with the necessary independence of Inspectors General and is contrary to congressional intent. This hearing will examine whether agency components at the Department of Justice have undermined the OIG's independence by withholding, filtering, or delaying the production of essential records based on a novel interpretation of the Inspector General Act, as well as restrictive readings of other statutes. In each of the three instances of interference we will hear about today, a review of agency correspondence with the OIG evinces a mindset that views DOJ leadership as the arbiter of what information the Office of Inspector General receives. It reveals an agency that believes the OIG must ask for and receive permission to review Department of Justice data and material, and that sanctions OIG investigations as necessary to advance its own supervisory responsibilities alone. The mission of DOJ's Office of Inspector General is to detect and deter waste, fraud, abuse, and misconduct in DOJ programs and personnel, and to promote economy and efficiency in those programs. Efforts to reduce transparency, such as those described by the Inspectors General in the August 5th letter, leave agencies vulnerable to mismanagement and misconduct and will not be condoned. Although not every Inspector General who signed the letter has experienced barriers to access, each one signed in support of the principle that an Inspector General must have complete, unfiltered, and timely access to all information and materials available to the agency that relate to that Inspector General's oversight activities without unreasonable administrative burdens. I welcome our witness today, the Honorable Michael Horowitz, Inspector General of the United States Department of Justice. I am pleased to have him here to describe the challenges he has faced and share his valuable insights so that we may evaluate for ourselves whether the executive branch is executing the Inspector General Act as Congress has intended and whether additional action is needed to restore congressional intent. And now it's my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte and members of the committee. I thank you for convening a hearing on this critical topic. We have an obligation to preserve the continued independence and effectiveness of the Office of the Inspector General at the Department of Justice. Inspector General Horowitz, we welcome you here before the House Judiciary Committee today. I suspect that membership of this committee is virtually unanimous in recognizing the need for vigorous oversight of the Department of Justice. No matter which party controls the executive branch, a strong and independent Office of Inspector General is key to protecting civil liberties, reining in executive overreach, safeguarding taxpayer dollars, and preserving the public trust. I have the privilege of having voted for the original Inspector General Act of 1978, both in the House Committee on Government Operations, then under the leadership of Jack Brooks of Texas, and subsequently on the House floor. It's my suspicion that I may be the only one that has done those things on this committee. I've reviewed the 1978 committee report accompanying the passage of the Inspector General Act, House Report 95-584. It was our intention then, and remains our intention today, that, quote, each Inspector General is to have access to all records, documents, etc., available to his or her agency which relate to programs and operations with respect to which the office has responsibilities. Simply put, the Inspector General is to have complete and direct access, emphasize, to all of the information he or she deems necessary to conduct thorough and impartial investigations. Recent legal analysis by the FBI's Office of General Counsel unfortunately suggests otherwise. They reasoned that the Inspector General Act actually prohibits the FBI from sharing certain sensitive or confidential materials, included but not limited to grand jury information, Title III wiretap information, and consumer credit information. Members of the committee, I find this analysis wholly unpersuasive. Nothing in the Inspector General Act authorizes the department or its component agencies to refuse even these materials to the Inspector General. Again, borrowing from the 1978 report, the Act was designed to assign to each Inspector General primary responsibility for auditing and investigative activities relating to programs and operations of his or her agency. That's a direct quotation. It's difficult to imagine how the Inspector General of the Department of Justice might conduct those auditing and investigative responsibilities without full access to relevant court documents, intelligence reports, or financial records. It's also difficult to imagine how the Inspector General might conduct effective oversight of the Department of Justice if the materials it requires can only be obtained with the permission of department attorneys. To be clear, the current leadership of the Department of Justice has taken extraordinary steps to make sure that the Inspector General has eventually received access to the material he seeks in each of the cases before us today. Attorney General Eric Holder and Deputy Attorney General James Cole are not the problem. They have both intervened personally on multiple occasions to overcome the FBI's objections and to compel production of the materials in question. I commend them for that leadership, but I do not know who will hold these posts in future administrations, and we should not be willing to entrust this key oversight matter to men and women who may feel differently about the effectiveness of the Office of the Inspector General. In May of this year, Deputy Attorney General Cole asked the Office of Legal Counsel to issue a formal opinion resolving this dispute. I hope that Principal Deputy Assistant Attorney General Carl Thompson and his team will adhere to the plain text of the statute and to our obvious intent, and grant the Inspector General unfettered access to every document in the department's possession. And if the Office of Legal Counsel finds enough ambiguity in the law to place any limit on the Inspector General's access to information, then the House Judiciary should be the first to act to correct their mistaken impression. Inspector General Horowitz, we welcome and we look forward to your testimony today and to your assistance if a legislative response is indeed required. And I thank the chairman and yield back.
Chair thanks the gentleman, and the chair understands that the gentleman from Ohio would make a brief statement welcoming the Inspector General.
I thank the chairman. I'm just looking, Mr. Horowitz, I'm looking at the letter that you signed along with a whole bunch of other Inspector Generals from August 5th of this year. The first paragraph talks about serious limitations on access to records. Second paragraph talks about the Department of Justice recently faced restrictions on their access to certain records. I was just going to say, welcome to the club. I think it's noticeable that 4 of the 6 Republican members here are also from the Oversight Committee, and I know we got a hearing tomorrow on this very issue, but we have been frustrated from the kind of response we've gotten from the Internal Revenue Service and frankly from the Department of Justice. So we share in your frustration, and we want to commend you for the work you've done. I've always been impressed with your service to the public and the work that you have done, but this is critical, and so I just wanted to say, Mr. Chairman, thank you for this hearing, and I want to thank Mr. Horowitz for his work and for being here today.
Chair thanks, gentlemen. Without objection, all other members' opening statements will be made a part of the record. We thank our only witness, Inspector General Horowitz, for joining us today. And Mr. Horowitz, if you would please rise, I'll begin by swearing you in. Do you swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much. Let the record reflect that the Inspector General responded in the affirmative. On April 16, 2012, Mr. Michael Horowitz was sworn in as Inspector General for the United States Department of Justice. As Inspector General, Mr. Horowitz oversees a nationwide workforce of more than 400 special agents, auditors, inspectors, attorneys, and support staff. The Inspector General has enjoyed a long career in both the public and private sectors. Mr. Horowitz previously worked as an Assistant United States Attorney for the Southern District of New York from 1991 to 1999. After this, he served in the Criminal Division at Main Justice, first as Deputy Assistant Attorney General and next as Chief of Staff. Mr. Horowitz has also spent time working in the private sector, most recently as a partner at Cadwalader, Wickersham, and Taft. He earned his Juris Doctor, magna cum laude, from Harvard Law School and his Bachelor of Arts from Brandeis University. Mr. Horowitz, we appreciate your presence today and look forward to your testimony. Your written statement will be entered into the record in its entirety, and then we ask that you summarize your testimony in 5 minutes or less. Thank you and welcome.
Thank you, Mr. Chairman, Congressman Conyers, members of the committee. Thank you for inviting me to testify today. Access by inspectors general to information and agency files goes to the heart of our mission to provide independent and nonpartisan oversight. That is why 47 inspectors general signed a letter last month to Congress expressing their concerns about this issue. I want to thank the members of Congress for their bipartisan support in response to that letter. The IG Act adopted by Congress in 1978 is crystal clear. Section 6A expressly provides that inspectors general must be given complete, timely, and unfiltered access to all agency records. However, since 2010, the FBI and some other department components have not read Section 6A of the IG Act in that manner, and therefore refused requests during our reviews for relevant grand jury, wiretap, and credit information in their files. As a result, a number of our reviews were significantly impeded. In response to these legal objections, the Attorney General or the Deputy Attorney General granted us permission to access the records by making a finding that our reviews were of assistance to them. They also have stated their intention to do so in all future audits and reviews, and we appreciate, of course, their commitment to do that. However, there are several significant concerns with this process. First and foremost, the process is inconsistent with the clear mandate of Section 6A of the IG Act. The Attorney General should not have to order department components to provide us with access to records that Congress has made clear we are entitled to review. Second, requiring the OIG to obtain permission from department leadership seriously compromises our independence. The OIG should be deciding which documents it needs access to, not the leadership of the agency that is being overseen. Third, while current department leadership has supported our ability to access records, Agency leadership changes over time, and our access to records should not turn on the views of the department's leadership. Further, we understand that other department components that exercise oversight over department programs and personnel, such as the Office of Professional Responsibility, continue to be given access to these same materials without objection. This disparate treatment is unjustifiable and results in the department being less willing to provide materials to the OIG, presumably because the OIG is statutorily independent, while the OPR is not. This disparate treatment once again highlights OPR's lack of independence from the department's leadership, which can only be addressed by granting the statutorily independent OIG with jurisdiction to investigate all alleged misconduct at the department. Indeed, the independent, nonpartisan Project on Government Oversight made the same recommendation in a report earlier this year, and bipartisan legislation has been introduced in the Senate to do just that. This past May, the department's leadership asked the Office of Legal Counsel to issue an opinion addressing the legal objections raised by the FBI. Attached to my written statement is a summary of the OIG's legal views regarding these issues. It is imperative that the OLC issue its decision promptly, because the existing practice at the department seriously impairs our independence. Moreover, in the absence of a resolution, our struggle to access information in a timely manner continues to seriously delay our work. It also has a substantial impact on the morale of the OIG's auditors, analysts, agents, and lawyers who work extraordinarily hard every day. Far too often, they face challenges getting timely access to information, including even with routine requests. For example, in 2 ongoing audits, we had trouble getting organizational charts in a timely manner. We remain hopeful that OLC will issue an opinion promptly that concludes the OIG is entitled to independent access to the records and information pursuant to the IG Act. However, should an OLC opinion interpret the IG Act in a manner that results in limits on our ability to access information pursuant to the IG Act, we will request a prompt legislative remedy. For the past 25 years, my office has demonstrated that effective and independent oversight saves taxpayers money and improves the department's operations. Actions that limit, condition, or delay access to information have substantial consequences for our work and lead to incomplete, inaccurate, or significantly delayed findings or recommendations. I cannot emphasize enough how critical it is to get these pending access issues resolved promptly, and hopefully OLC will shortly issue a legal opinion finding that Section 6A of the IG Act means what it says. This concludes my prepared statement, and I would be pleased to answer any questions that the committee may have.
Thank you, Mr. Horowitz. I'll begin questioning. The only explicit limitation on an inspector general's authority to conduct audits and investigations within its jurisdiction resides in Section 8E of the Inspector General Act. Section 8E is an extraordinary exemption that provides the Attorney General with the authority in carefully circumscribed circumstances to prohibit the Office of Inspector General from carrying out an audit or investigation. To invoke Section 8E, the Attorney General must explain the reason for his decision in writing and make a determination that a limitation on an IG's exercise of authority is necessary to prevent the disclosure of certain specifically described categories of information or to prevent significant impairment to national interests. My question to you is, has Attorney General Holder at any time during your tenure used this formal procedure to limit your office's access to material essential to a review?
He has not, and that's been one of the arguments we've put forward, which is that's the mechanism Congress set up to limit our access if there are sensitive matters. That's the provision that should be used, not simply a standing objection to our access.
In your experience, prior to your troubling experiences with the 3 reviews that you cite in your testimony, had any Department of Justice component ever asserted the right to make unilateral determinations about what requested documents were relevant to an Office of Inspector General review?
To my understanding from speaking to my predecessors and others in the agency, that had not happened before 2010.
How valuable is your authority to access grand jury or other sensitive material to your ability to execute rigorous oversight of national security matters?
It is critical, Mr. Chairman. These are the tools of the trade for the FBI, other law enforcement agencies. If we can't access every piece of information in their files when we're doing oversight of the FBI's use of these tools in its handling of various national security tools, we won't know the full answer to what's going on.
And according to your office, the FBI's withholding of the grand jury information is unsupported in law and contrary to both the Inspector General Act and exceptions to the general rule of grand jury secrecy. Would you outline the 3 reasons why the Office of Inspector General is entitled to access grand jury material that the FBI claimed was privileged?
Yes. Certainly, first and foremost, Section 6A of the Act could not be clearer, as Congressman Conyers just outlined in his opening statement. It is crystal clear. That's the primary reason. But secondarily, under the grand jury rules, prior to 2010, we had regularly obtained grand jury material because we have attorneys for the government working for us. I'm an attorney. We have a number of attorneys working on our staff. That would be the other exception. And then third, in the national security area, there's an additional exception in the grand jury rules that had, before 2010, been used to get us grand jury material. So there are at least 3 reasons why we should be getting this material.
You testified earlier that at no time has the Attorney General complied with Section 8E and given you testimony or a statement in writing as to why material would not be provided. Have you had the opportunity to have any verbal discussion with either he or the director of the FBI as to why they are choosing not to make this material available to you?
I have. I've raised my concerns with both of them, and the response from the department has been most recently to send the matter to the Office of Legal Counsel to evaluate the FBI's competing legal argument, and that is where the matter currently lies and has for several months now, and it's very important that that opinion be issued. I think it should be clear that we are entitled to it, but if there is going to be a contrary ruling, we want to know it sooner rather than later so that we can fix the problem and work with the Congress to fix the problem.
Have there been any previous opinions put forward by the Office of Legal Counsel with regard to this issue?
There have, and that again is one of our points, which is in 1984, prior to our existence, which we came into existence in 1988, OLC issued a legal opinion finding that the Office of Professional Responsibility was entitled to access grand jury information. We are at a loss to understand why that same opinion wouldn't apply to us, given we have the same oversight responsibilities, and on top of that, unlike with OPR, Congress, again, as Congressman Conyers quite clearly laid out, found that we should be getting these materials and put a provision in law that says that.
Thank you very much. Chair recognizes the gentleman from Michigan, Mr. Conyers, for his question.
Thank you, Chairman Goodlatte. You've anticipated some of the questions I was going to ask, and I thank you for raising them yourself. Just so that we're clear, Mr. Horowitz, am I correct in characterizing our discussion about the correct reading of the Inspector General Act as nonpartisan in nature?
Correct.
All right. We have in our possession several letters written over the course of late 2011 from Attorney General Eric Holder and Deputy Attorney James Cole. In each of these letters, over the objection of the FBI General Counsel, the department grants you access to sensitive materials. As recently as last Thursday, in his response to your office's report on material witness statute, Deputy Attorney General Cole again pledged, quote, to provide your office with access to all materials necessary to complete our reviews consistent with existing law. Are these fair descriptions of the role of the department leadership in this debate?
Yes. As I mentioned earlier, the department's leadership has made clear they will continue to issue orders giving us access. And so our issue isn't with getting the documents. It's, frankly, the process that's laid out compromises our independence.
Have the Attorney General and Deputy Attorney General been helpful to you?
Yes. In getting us these orders, they have been helpful. In issuing these orders, they've been helpful to us getting the access.
Now, as the only member of the committee that was voted for the 1978 Act, I agree wholeheartedly with your testimony. Congress meant what it said in Section 6A of the Act. Inspector General must be given complete, timely, and unfiltered access to agency records. In your opinion, why did the General Counsel of the FBI feel compelled to arrive at a different interpretation of the same statute?
I'd be speculating, frankly, as to what the motivation was, but I think it's clear, as you've indicated from looking at the opinion, and you have it, it's attached to my statement, that the IG Act, I think, trumps the arguments quite clearly.
Well, I hope the Office of Legal Counsel issues a strong opinion giving your office unequivocal access to the material and information that you require. And this committee is going to be watching that very carefully. I thank the chairman and yield back the balance of my time.
Chair thanks the gentleman and recognizes the gentleman from California, Mr. Issa, the chairman of the Oversight and Government Reform Committee, for 5 minutes.
Thank you, Mr. Chairman. General Horowitz, thank you for your courage. For Inspectors General to write a letter appealing to us over the people who appointed them but will not let them do their job, and to have more than half of all the IGs do so is clearly unprecedented, and I commend you for your courage. I have no doubt that this administration will attempt retribution against all of you. That is their pattern. You won't say it, but I will. This is an administration that believes justice delayed is justice given. They have delayed at every step. So although the distinguished ranking member is absolutely willing to say all the right things, he made one error. The fact is, there should be no commending of a man who sat in your chair, the Attorney General of the United States, and told us he wore two hats, one being a political hat, because the FBI does not operate in a vacuum. That information can be made available to you over the objections of everybody who works for him. And the policies that are in place are his choice. Now, I'm going to ask you just a few quick questions because you and I will be together tomorrow next door. One of them is there any basis, not just with your shop, but with any of the 74 Inspectors General, any of the 12,000 men and women, is there any basis to see that IGs have not been good stewards of confidential information over the many years since the Act was enacted?
We absolutely have been. We have handled, in my office, some of the most sensitive matters, including the Hansen matter, including the Christina Leung matter, including the 9/11 review that we did. We handled those documents entirely appropriately and consistently with the law.
And isn't it a practice of the very organizations you see, both on the FISA side and, quite frankly, across the Department of Justice, FBI and all the other agencies, ATF, isn't in fact one of the most important tools the clandestine nature of discovery? Isn't in fact a good FBI investigation often done in a way in which the target of that investigation is not aware that they're a target until after a substantial amount of information has been gathered?
That's correct.
So the very requirement for you to ask for access, doesn't that essentially negate the ability for you to look through such information as you need, and perhaps extraneous information, so as to not have the targets always know you're coming and potentially thwart your investigation?
It is, and I would note that in those earlier reviews, for example, in the Hansen matter, we had direct access to the information. We didn't even have to go through the process that we're now going through that's creating all the problems that we're facing.
And I guess one of the, I always say last question, and I don't really mean it, as you know, but an additional question is, if in fact the target knows, and if your statutory limit is in fact only against current employees of the department you're involved in, doesn't any delay cause the likelihood that both political and non-political appointees will move on, either through retirement or transfers?
We face that problem frequently. I've learned in the last 2 years that individuals under review or investigation retire, move on to another job before we're able to complete our work. There are an innumerable number of issues that result from the delays that we face that are problematic.
And just hypothetically, let's say that Congress is interested and sends you a letter because we're concerned that the people doing the lowest learner IRS targeting investigation are in fact tainted in some way, either because of their conduct or some other matter, and you agree to look into it. Isn't that a classic example where it has to be done timely or irreparable harm to the process occurs?
There are so many reviews that we do that it's imperative that we be able to do them timely, and we are not able to do that right now in a number of our ongoing reviews.
Well, Mr. Chairman, Mr. Ranking Member, I want to take a moment just to say that one of the few areas of specific legislative jurisdiction of the Oversight Committee is, in fact, the Inspector General's. And it's my intention to conclude tomorrow's hearing and take draft legislation, which has been done on a bipartisan basis over the last several years, working with the Inspector Generals and with their oversight groups, and author that legislation. And I hope both of you and your staffs will look at it ahead of time, give us your input, because I think today's hearing here tells us that we must, as a body, restate some principles and make some reforms in the IG Act to make it clear for the next president and the next administration that we really meant what that legislation said. And I yield to the ranking member.
Thank you. Mr. Chairman, can I ask unanimous consent that the gentleman be given one additional minute?
Without objection.
And I yield to the gentleman.
And I thank you very much, my friend. But I do not think that I am in error in commending either the Attorney General or the Deputy Attorney General, because since 2010, when the FBI first advanced this argument, the leadership of the Department of Justice has bent over backwards to make certain that the Office of the Inspector General has access to every last shred of evidence it requires. Attorney General Holder, Deputy Attorney General Cole have intervened personally at least a half dozen times. And I thank the gentleman.
I thank the gentleman. I just ask Mr. Horowitz to comment on whether those interventions in fact represent the kind of timely and unobstructed activity, particularly when the ranking member said 6 times. Isn't once enough to show leadership and 6 times a pattern of obstruction that you're not able to overcome?
I would say what the problem with the process, as I laid out, is significant in terms of our independence. It also delays our reviews because we have to keep going up the chain to get to the leadership, and that's the continuing problem we face, and which is why the leadership has made the decision to send it to the Office of Legal Counsel. We need that decision promptly. That's what we need to hear right away.
Thank you. The time of the gentleman has expired. The chair recognizes the gentlewoman from Texas, Ms. Jackson Lee, for 5 minutes.
Let me thank the witness for being here and helping us ferret through what are important issues. And I certainly hope that we're not on another chain of condemnation of the Obama administration, that we are actually trying to get to the facts that will help the oversight of this Congress and as well work with the IGs at various agencies. I understand the DOJ, EPA, and Peace Corps. Certainly Peace Corps shocks me because they are humanitarians around the world, and we hope there's nothing that they're doing except sending great Americans forward to be of help. But let me start by saying, have you had an absolute bar to being able to address issues that have come to your attention, meaning that there has been an absolute dropping of the iron gate, the steel gate, the concrete wall. What have you faced in trying to do the work of the IG, the Inspector General?
Yeah, the issue hasn't been roadblocks to our undertaking reviews. The issue has been getting the information to timely complete them. That's been the big problem.
And you know, that is a distinction, to be very honest with you. I want to help you find a system that works, but as you well know, and as a practicing lawyer previously, I'll use the term discovery. And many times, particularly if we're in litigation against one of the big guys, there are several ways we can interpret discovery. One, that they are in essence roadblocking, or that the documents, whether it is a governmental entity, which of course you know, we have immunity issues, but it's down in the bowels somewhere. So my question to you is this you know, an issue of getting a system that works because they're in the bowels? Remember, we have gone tech, but 5 years ago, 10 years ago, or as many of us started in the United States Congress, for example, we were all paper. And we packed up papers at the end of the session. We boxed them up. We thought we were labeling them, and they were somewhere in a distant mind. Can you discern that we are speaking of what every American understands? I filed it away somewhere. But where is it? Would you?
It's a great point, Congresswoman. In fact, I have to say in many respects, we feel like civil litigants where we're opposite the party that's going through documents and having lawyers look through documents. For example, at the FBI now, the process in place because of their legal position that they're not sure what we're entitled to legally, they send all of their documents, all of our requests now go through their Office of General Counsel.
And do you say they're sending them in good intent?
They are sending it there because of their legal position. Yeah. The result, though, is we have lawyers like civil litigants. We're sitting waiting for their discovery reviews. We end up sometimes getting documents from them and then learning from witnesses documents weren't produced. That's the problem with this situation that's been set up, and it has to be resolved, and it should be resolved in a way that gets us access immediately, frankly. There's really no reason for this process to even be undertaken.
But let me get you to not put words in your mouth, but this is not seen by the IG, because I'm going to get to the point of a solution. This is not seen in the IG as a malicious intent. Is this a malicious intent?
No, I'm not here to suggest a malicious intent, but the consequence of the legal argument put forward and the time that it's taken is that our reviews go through these processes, and we ask for organizational
and this has gone over a series of administrations. I don't know how long you've been here, but this has been ongoing. Whether it's been President Bush administration or there's a system in place. Is that my understanding?
Well, on the IG side, my understanding is this began in 2010. I started in 2012, but the FBI raised this objection
and this is on the FBI end of it.
Correct.
But you see no malicious intent. So the question is, we're holding a hearing here, and I want the hearing intent to be a resolution, not a condemnation.
Correct.
And so I think it is important for us to look, certainly as you well know, if we're not litigants, but litigants each have individual rights. I would have the right to protect my client, and therefore in discovery I'm going to make sure that I'm giving precisely what is asked and not something that is just rating, and you on the other side will be doing the same if you're representing a client. In this instance, we want transparent government. But as well, the FBI or the EPA or those producing documents should in fact be adhering to the law. If the law is presently or a structure is presently in place that came in 2010, let's see how we can work it better. But FBI has a right to counsel, EPA has a right to counsel, and you have a right to transparency. Am I arguing or making the point that you're now saying that you need some system that allows these documents to come forward?
Yeah, and what I'm suggesting is the mindset has to change. In our earlier reviews, for example, the Robert Hansen matter, very sensitive matter, we had direct access to FBI information. No one tried to interpose lawyers in that regard. We are part of the Department of Justice. We should have, and Congress set up a system in the IG Act, as Congressman Conyers laid out, that says we're there to oversee them. If we're going to oversee the FBI, their lawyers should not be going through and deciding and filtering what documents we get and how fast we get them.
Well, you have just given us a framework to be able to address, and you're from the DOJ. We don't have the inspectors from EPA. We don't know what their issues are, or Peace Corps, and as I said, I think of them as twinkle toes to a certain extent in terms of the work they do. But what I would say to you is that this is a workable, you're presenting facts, and I want to be clear as I end my query that, and I know there's a series of sections that you come under and offered sections going forward. As I end, could you precisely just give, is that your suggestion to move that lawyer structure, or could you work with a lawyer structure that was then had a direction that their job is to be fair and cooperative with the IG? Because if you remove them totally, could you work with that?
Time of the gentlewoman has expired. The Inspector General can answer the question.
Thank you. Yes, I think the lawyers need to be removed from the process for routine requests. There may be issues that arise that require a legal opinion. Right now, what's going on is every request goes that route. We should be able to get direct access to information. But witness, a whistleblower, a witness at the FBI wants to come to us with information, with documents, they ought to be able to do that directly. We shouldn't have to go make a request to the legal counsel, have them go look through the documents and get them eventually, hopefully. But then we often, as I said, learn from other witnesses that there are more materials out there that are relevant to our review.
Thank you, Mr. Chairman, for allowing me to have this query. I think that we can solve a transparency
Time of the gentlewoman
approach
has expired.
without condemnation that I hope is not coming forward in this hearing. I thank the witness. I thank the chairman. I yield back.
The chair recognizes the gentleman from Ohio, Mr.
Chairman.
Gordon, for 5 minutes.
Mr. Horowitz, I just want to make sure I understood your last statement. Every single request that information you're trying to get access to now goes through the Department of Justice's legal counsel?
I'm sorry, the FBI Office of General Counsel.
Their general
FBI has
counsel.
set up that process.
The FBI has.
Correct.
And you're saying that's not political?
I'm just the Office of General Counsel is not a political appointee. They
I understand, but
send it through their Office of General Counsel, and
that just
there is
happened.
no
How long ago did that practice start?
within the last 2 years, 2 to 3 years. It may have
since
been
you
just
came?
before I got. It may have been just before I came.
Okay. I mean, I'm concerned about all your work, but I'm particularly concerned about one issue that's been a focus of the Oversight Committee and some other committees, and that's the targeting by the Internal Revenue Service of people exercising their First Amendment rights. And frankly, have been very disappointed in the criminal investigation at the Justice Department for a number of reasons. 15 months ago, then FBI Director Mueller sat right in the chair you're sitting in, was asked 3 questions. Who's the lead agent? How many agents have been assigned to the case? And have you interviewed any of the victims? This is 1 month into the investigation when it's been the major news story in the country, and his answers were, I don't know, I don't know, I don't know. Didn't exactly inspire confidence at that point. And then since then, there's been early this year, the leak by someone at Justice that no one was going to be prosecuted. There's been the president's now famous comment, no corruption, not a smidgen. And of course, the lead agent, Ms. Bosserman, has maxed out contributions to the president's campaign, and yet she's the lead agent, or excuse me, not agent, but lawyer on the case. So in the second paragraph of this letter you signed, I think with 46 other inspector generals, it says this: the Department of Justice faced restrictions on their access to certain records available to their agencies that were needed to perform their oversight work in critical areas. So I want to know, what were those critical areas? Were you denied access to oversight work in critical areas? Was any of those critical areas related to the situation at the Internal Revenue Service and the criminal investigation that's going on there? Any inquiries in that subject matter that you were denied access to?
No, that is not an area that I was referring to in my.
Anything related to that at all? I know we have asked you to look into certain things. We've asked you specifically, I think, to look into the fact that Ms. Bosserman was selected to sort of head up this investigation. So you were not denied, you didn't face any restriction or denied access to any information regarding that?
We have not faced any document restrictions with regard to that matter.
Are you, so changing gears a little bit then, one of the other issues that we were very nervous about brought to our attention a few months ago was the fact that the Internal Revenue Service gave 21 disks of information to the FBI regarding the targeting issue. That information was given to the FBI in 2010, 1.1 million pages. Some of that information contained 6103 confidential taxpayer information, donor information. Mm-hmm. Are you aware of that issue, Mr. Horowitz?
I am, from the news stories and various letters.
Has your office looked into that at all, just in any type of elementary way, or examine any of that information at all?
We try not to talk about matters that are non-public in our office and what we might look at or we might not be looking at.
Well, let me ask you this way. Are you concerned about the fact that the Justice Department, specifically the FBI, had confidential taxpayer information? They had it for 4 years?
Yes, I have noted that information and taken note of it.
Okay. Last question then. Just to be clear, though, none of the access you were denied, information you were denied in your oversight work dealt with the Internal Revenue Service?
That's correct.
Okay. Mr. Chairman, I yield back.
Chair thanks the gentleman. Recognize the gentleman from Utah, Mr. Chaffetz, for 5 minutes.
I thank the Chairman and thank the Inspector General. I appreciate his work and his efforts, and I had the pleasure to interact with you on several different occasions, and you play a vital role in our system of checks and balances, and we wish you nothing but success and want to make sure that your efforts are unimpeded. And so I want to ask you some questions, though, about Operation Fast and Furious. Part of the indication from the Attorney General was that he could not answer questions, would not provide more information to the public, in part because the Inspector General was doing a review. How do you summarize your ability to access information regarding Fast and Furious?
We had difficulty, and this occurred just before I arrived, and of course then I picked up the investigation, right. But we had difficulty just before I arrived in gaining access to the grand jury information because, as you know, Fast and Furious raised a number of prosecutive issues, as well as Title III information. As our report made public, there were numbers of wiretaps. We had difficulty obtaining both of those in a timely fashion because of the objections raised by components to providing it to us because they did not read Section 6A of the Act as giving us authority to look at that information.
So what percentage of the information could you actually see?
I'm not sure I could put a number on it, frankly, because I wasn't here at the time. Right. I wasn't the IG at the time that these requests were going on. But I do know there was a fair amount of information that was potentially grand jury information.
And your interpretation is you should be able to talk specifically about grand jury information, then also about the other.
So I think it's quite clear in the first instance is that Section 6A in the IG Act means we should have unfiltered, timely access to all records. The agency doesn't get to pick and choose. So that would be the first basis. The second is we have always gotten grand jury information up till 2010 from the FBI and other department components, either through the IG Act or through one of the exceptions in the grand jury law, which has an exception for attorneys for the government. I am an attorney. We are attorneys for the government. I work for the Department of Justice. That should be, I think, self-evident, but that apparently has not been how it's been interpreted by the FBI.
And how many people report to you in your group? How many IGs are you overseeing?
My office has over 400 employees.
And so the process now, they're having to go and ask permission from who is it that they're specific to the FBI? Who are they having to ask permission from?
So what happens now is we send our requests because we don't have unfiltered access. We now have this review going on between our request and us getting the documents. We make a request. The FBI, the Office of General Counsel, looks at it, and if it has an objection, it raises an objection, and then we start this process going.
And what are the so-called objections? What are they? What are their excuses as objections?
Well, we've had the grand jury objection. We've had objection to wiretap information, to Fair Credit Reporting Act information. We also had, during the course of our review, an objection raised to personally identifiable information, for which there was no basis for an objection, but it took months before it got sufficiently elevated and the FBI withdrew its objection and we got the materials.
Now, at one point, there was an objection about an organizational chart. Can you tell me about that?
Correct. In 2 of our reviews, that has come up. One of the audits, an FBI-related matter relating to cyber, our review on cyber, the witness we were speaking with was prepared to hand us the organizational chart that we asked for, but we were told he couldn't do that because it had to go through this process at the Office of General Counsel to review it, and so we were delayed for weeks. I actually had to send an email to the General Counsel saying, I don't understand how this can be the case.
A simple organizational chart.
Simple organizational chart. In addition, recently with the DEA, we requested an organizational chart. We got an organizational chart with names whited out. We then went back and said, well, we need the names because one of the purposes is to see who we need to interview. And we then got a makeshift, unofficial organizational chart with names. I had to elevate that to the administrator in order to get the organizational chart we were looking for.
Mr. Chairman, I'm so glad we're holding this hearing, glad we're doing so in the Oversight and Government Reform Committee tomorrow as well. This is outrageous. The Inspector General should have unfettered access to all the information they want. And when it's gotten to the point where they can't even see an organizational chart, it's reached the level of absurdity that must be addressed immediately. I appreciate the bipartisan notion on this, and I yield back. Thank you.
The gentleman yield.
Happy to yield.
The gentleman's point is well taken, because not only does the organizational chart give an indication who they need to talk to, it also gives an indication of who should be held accountable, and accountability is, I think, a very serious issue in any government, but it's certainly an issue with this government. At this time, it's my pleasure to recognize the gentleman from North Carolina, Mr. Holding, for his question for 5 minutes.
Thank you, Mr. Chairman. In a limitation that's unique to DOJ, the Department's OIG does not have authority to investigate all allegations of misconduct within the agency. So while the OIG may review alleged misconduct by non-lawyers at DOJ under Section 80 of the IG Act, it does not have the same jurisdiction over alleged misconduct by DOJ attorneys when they're acting, as lawyers in the department. If you could explain for us, how this distinction came about and kind of how the process works.
This is really a historical anomaly. It's because of the fact that OPR existed before we did in 1988, and when our office was created in 1988 by Congress, they decided at that time to keep OPR in existence and have this jurisdictional limitation so that all matters went to OPR. The argument being that for many years OPR had experience doing these matters, and so they should have authority. We're 25 years later now. We have been given authority over misconduct by all the other parts of the Justice Department. We've exercised that appropriately, effectively, and most importantly, independently. It's time for us to have authority over all misconduct. There's no reason that agents' alleged misconduct should be reviewed by the OIG, but attorneys get to go into a non-statutorily independent body for their conduct to be reviewed.
So are you advocating, I guess, for, if you're advocating for that, would OPR continue to have any role at DOJ, or are you saying this past its usefulness?
I think that would obviously be a decision Congress would need to make, but in the past, when Congress has created these situations, they've kept in place, for example, the FBI's OPR. And what has happened now is we have right of first refusal. So we take the most sensitive cases, the cases where there needs to be independent review, where there's criminal conduct alleged, where there's high-level officials involved, and OPR for DEA, FBI, the Marshal Service, et cetera, handled the other matters. That could stay as the process, or Congress could decide that we should have all attorney misconduct, no matter who or what it is alleged to have done.
Right. In addition to OPR, there's the DOJ's National Security Division Oversight Section as well. And as you've put forward in your testimony, they're provided access to the information that the OIG has had trouble accessing, despite the language of the statute. So what is your understanding as to why DOJ leadership is more forthcoming with these documents and materials to these other entities as opposed to OIG?
Our presumption is because we're independent and they're not, and so there appears to have been a conclusion that there indeed does need to be a finding that our reviews are of assistance to the leadership. It's self-evident for the other entities, OPR and SD, because they are working for the leadership. We are statutorily independent. Congress set it up that way, and therefore it would appear the decision's been made that somehow we need to go through this process so that it's clear our reviews are being overseen or are being of help to the leadership. And of course, that's entirely inconsistent with what Congress has set up in the IG Act.
All right. Thank you. Mr. Chairman, I yield back.
Chair thanks, gentlemen, and recognize the gentleman from Texas, Mr. Gomert, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Inspector General. We appreciate your being here, and we appreciate your candor and your efforts at trying to get records. We had the Attorney General testifying here early during his tenure as Attorney General, and there was a reference about how close he was to, that he made, about how close he was to the Inspector General at the time. That caused me concern because I'd hoped that there was more independence from an Inspector General. Nobody is supposed to be an Inspector General and be big buddies with the Attorney General, although he's called me his buddy. I take that as endearment, even though he said it, you don't want to go there, buddy. But we never intended for you to have trouble, have any impediment to getting documents. And just so you're aware, Mr. Horowitz, for almost all of this administration, I've been seeking the documents that the Justice Department gave to the defendants in the Holy Land Foundation who were convicted of supporting terrorism. This Attorney General has used such lines as, classification issues, things like that, when actually it's very clear if you give documents from the Justice Department to terrorists who are convicted, then it's probably okay to give them to Congress. And yet still, the most that I've been able to get after all these years is a notice that I can go online and check out some websites that have some of the documents that were admitted. So I share your pain in trying to get information from this administration that should have been a slam dunk. Very easy. Just give me this, give me the papers, whatever. I've been through boxes. I've been through, masses of CDs as a judge and a lawyer. So what do you think we can do? Just the top thing that this Congress could do, well, put it this way, the House could do to make your job easier and make your position more effective?
I think, frankly,
The number one.
Given where this is at OLC right now, I think having comments by the ranking member about the intent of Congress and pressing for an answer to the question by Congress on does Section 6A of the IG Act that Congress passed mean what it says? That's the number one issue we are waiting to get an answer to right now.
All right. Well,
Gentlemen, yield.
yes.
I just wanted to invite you to join with me in this endeavor because I think you're interested and have learned a lot about it.
Well, and I would certainly be willing if I would think that a sense of the House might be what we should try to pass as quickly as possible to make clear about our bipartisan belief in the importance of Inspector General. And I very much appreciate the ranking member, the former chairman, understanding that this should be a bipartisan issue because we change majorities, the White House changes, but we have got to make sure Inspectors General can get the information they need. So I very much appreciate the ranking member.
Thank you. I look forward to working with you.
Mr. Horowitz, you don't have to come back here for a hearing to seek individual assistance in your job. any of us that can help, I know all of us, I know the chairman, any of us would be willing to assist in any way. You let us know what we can do. It is critical for any democratic republic, as this is supposed to be, to function efficiently if an inspector general cannot get direct access to the information he needs. So thank you for being here today.
Thank you, Congressman.
Chair thanks the gentleman and recognizes the gentleman from Texas, Mr. Farenthold, for his questions for 5 minutes.
Thank you, Mr. Chairman. Mr. Horowitz, thank you for being here as a member of this committee and the Oversight and Government Reform Committee. I'm acutely aware of the benefits that the Inspector General community throughout government provide to the citizens of this country. You're the first line of watchdogs right there with the whistleblowers that combat waste, fraud, and abuse in the government. The idea behind inspector generals were they worked within the agency, but they were independent. So they understood how the agency worked. There felt like there'd be less reluctance of the agencies to share information with the IG for internal investigations and the like. But the stuff we've been talking about and hearing about today has taken this to into politics. And that's where I think the trouble is. Again, one of the advantages of the IG is they're within the organization, so ostensibly nonpartisan. I mean, that's the intent. And rather than having Congress subpoena a bunch of documents and do an investigation ourselves, where politics get infused in it, a lot of stuff can be taken care of by the IGs within the agencies. But this situation seems politicized. Is that the sense that you get? There's a political element to this?
From our standpoint, what we've seen is simply, in lots of different reviews, objections being raised. No one has said to us that it's being done maliciously or for other reasons. I'll let others decide, how this all came about and why.
Well, it's certainly been my experience in trying to pry information out of this administration that delay, stonewall, and quite frankly, when dealing with the IRS, outright lie seems to be the rule of the day. And eventually, some of these, y'all got some of the documents that y'all were after, but this was only after the leadership in the DOJ determined that they were positive. And again, this points to politicism of it. And I guess I don't have another question. I just want to express publicly and on the record my dismay at the dismantling of what I think has been one of the most effective oversight and reform tools within the government. The Inspector General is being co-opted and, in my opinion, politicized and misused. It's a horrible indictment of an administration that early on said they wanted to be the most transparent administration in history, and clearly that's not been the case, and this is just another example of it. And I struggle not to be numbed by it. It's like we have another scandal that comes out every 2 weeks, any one of which would have had folks' head exploding not that many years ago, and it's disheartening. And I'm going to yield back the remainder of my time. Thank you.
Chair thanks the gentleman. Recognize the gentleman from Georgia, Mr. Collins, for 5 minutes.
Thank you, Mr. Chairman. As coming back in, we get a lot of things going on, but I'm glad you're here, and it's really good. Serving on oversight and as well as judiciary is the importance of what you do is really amazing to the government. I wish we actually had more work in this way. And I think, for my folks in the 9th District of Georgia, we're just basically stunned to learn that you don't have access to information that frankly, I, as an attorney, but others as well, believe you are entitled to. Leading up to the letter, leading up to the issues, based on your experience, is it particular people? Is it somebody? Is it just an agency culture under this, environment and this agency leader? What do you think will lead up to the necessity for them to write this letter and say, we don't think you're getting the access that you need?
Yeah, this all began a couple years before I became IG, but there had been a series of reports that we issued and reviews that we issued that were critical of some of the handling of some matters. This followed shortly thereafter. And what happens once this begins is we start to see this among other components and in more regular reviews, and the roadblocks become more regular. And that's the problem with not resolving it and dealing with it promptly.
Well, and I think it's just one that gives the impression, if you're, especially a government-to-government kind of, if you're roadblocking yourself, it's like there's something. Frankly, it just leaves the opinion you're hiding something, and that's just the way it looks. Your review of the Department's use of material witness statute, which was published this past Thursday, reports that FBI conducted a page-by-page pre-production review of all documents requested by the OIG and said redacted anything it considered to be grand jury material. As a result, the review states documents were not useful, and the review came to a standstill. While the Deputy Attorney General ultimately granted you access to certain documents under the foreign intelligence exception of the Federal Rules of Criminal Procedure, this avenue was not without its delays. How long did the OIG have to wait for the grand jury material in all?
It took us almost a year from start to finish to get the material we asked for in terms of completeness of the process.
And there was really, at this point, no reason for that year's delay?
There was no reason, from our standpoint, certainly.
Okay, so basically, again, we're stopping, hiding, whatever you want to call it, something. Because frankly, if you're going to stick with a story, it's like I've told my kids: if you're going to lie once, or start telling stories once, then you're going to have to tell the story the whole way through.
Right.
And now they're coming back and now giving you the information when they first said they couldn't.
Right. And I'll add, on top of the delay to our review, you have a whole bunch of lawyers in the FBI who have a lot of things on their plate, spending time going through page-by-page documents we should be getting. You have my auditors and teams, lawyers, et cetera, being put on hold, not being able to complete the work. So there's waste along with it. It's not only the delay, there's this wasted resources that are going on.
I understand. Well, and I think that's another whole issue is we got to deal with is wasted resource when we're in an environment where we're trying to find every penny we can to properly use taxpayer dollars. Also, according to that report, while they're waiting for a DOJ attorney to produce the grand jury material, the FBI was busy redacting several other categories of information from document it was providing to you. What information was that, and what was their rationale?
Well, the FBI had come to us with a list of areas that it had concerns about producing, and so we ended up having to negotiate and discuss with them a whole variety of categories beyond that before we could get what we thought was complete. But again, since they're controlling the process and we're not getting direct access, we're relying on their interpretation of these statutes and what's relevant and not relevant.
And again, not to disparage in a large sense, but in a sense, we're looking at an investigation here that is coming internally as something that should be worked together on, and not pitting us against them. This is just an honest, truthful mentality. What are we doing? And I think that's the look. We just got back off of a working period in which I was in 3 town halls and everything. That's the biggest thing that I hear from most of our folks is they don't trust the government anymore. And I've made many discussions about this. They come up and they say, what can we do? We've got to restore trust, and part of this trust factor is going to our own Inspector General process, going to our own internal checklist, and making sure that we're not, for just the sake of what I call busy work, doing that. And the letter was courageous. I mean, I think there's a lot of things that could be happening in my short amount of time here real quickly. Other than the hearings and bringing this, and I appreciate the chairman for doing this, what action do you hope Congress will take in response to what has been brought forth today and what we've talked about?
I think the kind of statements and message that has been put forward by the ranking member today, who talked about what happened back in 1978, but other statements, for example, in 1988 and in the 1993 reform as to our office, what was meant by access to information. Did Congress intend us, when it gave us authority in the early 90s to oversee the FBI and the DEA, that we should actually be able to look at all the records in their files like grand jury and Title III information? The answer has to be yes. Otherwise, giving us that authority would be largely meaningless.
Well, I think you summed it up very well, and I thank the chairman for bringing this and the ranking members to be a part of this, because if you don't have access, then basically we're telling the American people we're doing something we're not doing. Right. And that has got to step to this trust issue. Americans demand more. We've got to be accountable to that and transparent to that. I thank you for what you do. And with that, Mr. Chairman, I yield back.
Chair, thanks, gentlemen. The chair has one additional follow-up question, and then I'll check with the ranking member, see if he has any additional questions he'd like to ask. The FBI has argued that based on its interpretation of Section 6B2 of the Inspector General's Act, it has the authority to refuse your request, Office of Inspector General request for documents so long as it deems its refusal to be, quote, reasonable. Will you explain the basis for this conclusion by the FBI and your opinion as to whether there's any merit to that position?
Frankly, I don't think it has any merit. I think Congress quite clearly put in place in Section 8E of the Act the process that is to be followed if there are sensitive documents that shouldn't be disclosed to the IG or the IG shouldn't be able to disclose publicly. That leaves that power with the Attorney General, not with anybody else in the organization, and so we disagree entirely with that.
And where does that phrase reasonable emanate from? Do you know?
I think that's their interpretation of the IG Act.
Thank you.
Mr. Chairman, I have no additional questions. I want to thank again the Inspector General for his very thorough and complete testimony today.
And I want to join you in thanking Mr. Horowitz for his testimony, and we will work together in a bipartisan way to make sure that anything the Congress can do to bolster your ability to conduct neutral investigations into how our government, under any leadership, operates. I think it's important to set the precedent correctly, as we did in 1978, and if we need to reinforce that today, we'll do so. So I thank the gentleman, and this concludes today's hearing, and we thank the Inspector General for joining us. Without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record, and this hearing is adjourned.